Welcome, everyone. I'm Robin Harris. I'm the president-elect for Howard County Association of Realtors, and I want to thank everybody for attending today. We have well over 600 people registered, and it looks like we have about 350 logged in right now, so I'm sure people will be able to get the recording afterwards and be able to learn all about our new contracts. I just want to remind everyone that tickets and sponsorships for the Howard County Association of Realtors installations and awards gala on October 27th at the Meriwether Lake House Hotel are available on our website, and that's www.hcar.org. And while they are on the website, be sure to check out our calendar for upcoming CEs, and which are free to all of our members. And I'm going to hand this over to Kathleen Dartez, who's the Director of Legal Affairs for the Maryland Realtors. Thanks, Kathleen, for keeping us informed on contract changes coming our way as of October 1st.
Thank you, Robin, for the nice introduction. And thank you especially to Sarah for setting this up. You guys, Sarah went to a lot of work. I know you all know there's a lot of changes to the contract and some new and revised forms. And Sarah was, is relentless too strong a word? No, Sarah was pretty relentless. She had to make sure that she got an event on your calendar for all of you, and also extended the invite to the folks at Coastal as well. So that was really a great effort, and really appreciated, Sarah, and happy that so many people are able to join today. And I don't want to spend a lot of time talking about background because we have a lot to go through. And, Sarah wanted to be respectful of everybody's time and not make it a huge long session. So I'll go ahead and get started. I think just real briefly, many of you have served on the, statewide forms committee or your local board committee, forms committee or other committees. So you know how committees work in general, but the process, what happened this year, the contract was revised. Craig Wolf, who's the current Maryland Realtors president, he had, you guys all know Craig, he had talked to a lot of people, and people had made certain suggestions about the contract, and it's too long, or it was disorganized, or whatever. So one of his initiatives for this year was to put a task force together to review the contract and see if it could be restructured or reorganized and made into a better flowing document. So the task force was convened. Tom Drexler led the task force. There were 9 members who served on that. I believe all of them had also served on the statewide forms committee. So they met regularly, and then they came up with some recommendations. And again, it's a process. The recommendations go to the statewide forms committee, which reviews them, approves them. It also has to be approved by Maryland Realtors Executive Committee. So everything you're seeing today, the changes to the contract went through the task force process. All of the other documents, I believe, went through the regular statewide forms committee process. But I'm going to go ahead and start sharing my screen, and we will start in a place where I hope the logical place to start would be the contract. That's going to be, like I said, that was sort of the original impetus for the task force to revise and update the contract. So far, we've received good feedback on this. Let me actually, before we go any further, let me just point out, someone had asked where these forms were available, or if you would be able to get a copy of these forms. The answer is yes. All of these forms have been uploaded on the Maryland Realtors website. These are instructor versions. Maybe I don't, this one might not be, but they're instructor versions, with the changes highlighted. You can see that. That's on our website now. So you could go there right now and pull up the forms and look at them, save them, print them out, frame them, whatever you want to do with them. And the forms have also been pushed out to all of the forms vendors. They received their versions of these yesterday. So we've received confirmation back, .loop, DocuSign, Zip Forms, MBAI forms, all of the vendors who have licensing agreements with us have received these forms, and they're going to have all of the new forms available on October 1st. So you can access them through our website. If you're not sure how to access them, otherwise, I suggest speak to your office manager or broker and see, how your .loop is set up or whatever it is. All right, so the main thing with the contract, I said, the contract didn't change in too many substantive ways. The main change in the contract is just the organization and the structure of the contract. You can see now there's like a title here, Section 1, General Contract Provisions. The contract was set up, it's got 7 sections now. General Contract Provisions is first. Payment of the purchase price is second, the deposit, things like that. Property condition and inspections is the 3rd section. Property specific disclosures, that's the fourth section, is this a condo or an HOA, that type of thing. Section 5, general disclosures, and those are going to be the disclosures generally that are required by Maryland law. That's going to be in there. The sixth section is going to be transfer of title and closing. There's probably going to be something in there that I think you guys will be happy with. And then section 7 is the breach of contract and dispute resolution. So that's sort of the organization and structure of it now. And so far, like I said, we've received good feedback. I think people find it flows a little bit better. Let me this is the first page of the residential contract of sale right here. The changes are highlighted and you can see, what's this? Look, there's a paragraph number. Time is of the essence. I think all of you guys remember the old version of the contract had time is of the essence up in a box above the title of the document. And I'm not even going to speculate. If everybody on the call, please don't put in the chat, but I suspect that a lot of your clients never read that. I don't know if you went through that, but people may or may not have paid attention to that. And time is of the essence is a very important provision. It means that time is of the essence. If you miss a deadline, it could potentially result in the other party having the ability to terminate the contract. Or if you're supposed to do something within a certain time frame and you don't, you could forfeit the right to do something that you wanted to do. So the task force did make this recommendation that this is important enough that this should actually be part of the contract, not just a little headline or a head note above it. So that is now part of the contract. You should review that with your clients when you're going through the contract, right? So that was the first part. The second part here under the addenda and disclosures, there are some new addendas. There are also some addenda that have gone away, which I think you may be happy with. You do not see a first-time home buyer addendum. You do not see, let me make sure I get my list here. You do not see an as-is addendum. We see another one, but we don't see an as-is addendum. Inclusions, exclusions, and utilities addendum is not there any longer. And disclosure of leased items addendum is no longer there. They've some of them have transformed into different versions. The additional as-is provisions, we'll talk about that shortly. BAT, the best for the sewage systems, septic systems on the property. We'll talk about that as well. This one, I think people will like: inclusions, exclusions, leased items, and utilities. We'll talk about that later, but the main thing for you to remember, we did include this as a list of addenda. The quick version of it is what's going to happen now when you're this listing agent, you meet with the seller is going to complete the form as part of the brokerage agreement. Hey, I'm going to complete this inclusions, exclusions document. That document is now going to become part of the contract. I'll show you the form in a few minutes, but basically that document, as completed by the seller, it's going to be attached as an addendum to the contract. The buyer and the seller are both going to sign on it. I think hopefully this would be popular with buyer's agents. You're not going to have to go back on Bright MLS and look and see and which line did that line up with? Am I forgetting something? Did I mark the wrong thing? It's going to be the same form used throughout. So hopefully that'll be more consistency, fewer errors, and easier on the listing agent as well, I would think, quite frankly. Tenant occupied addendum is on there as well. All right, so this change is relatively minor. The next one, paragraph 12. Previously, the language said the buyer and the seller could conduct the transaction electronically, and I think the task force said that's not technically what's happening. It's really being executed electronically, so the verbiage was just tweaked a little bit. Nothing substantively was changed there. Leases, this one is important, and a sentence was added. Leases, the first sentence was the same as it was before. Seller may neither negotiate new leases nor renew existing leases for the property which extend beyond settlement or possession date without buyer's written consent. This is the new sentence here. Seller warns that the property is not tenant occupied nor subject to any leases unless otherwise stated in an attached tenant occupied addendum. The tenant occupied addendum has existed for some time. This is really just to highlight for you guys to pay attention. If the property is occupied, if there are tenants in the property, there was one disciplinary case. I hope nobody thinks this, but if you think that the lease automatically terminates when the property is sold, that is not true. The lease doesn't automatically terminate if the property is foreclosed upon. A lease doesn't automatically terminate if it's an REO property or a bank-owned property. So the seller should be very careful. If there is a tenant in there, if the property is occupied, the seller absolutely positively, you listing agent absolutely positively, you buyer's buyer's agent, if you know the property is occupied by someone other than the owner, absolutely positively want to include that tenant occupied addendum. If you haven't looked at that, take a look at it. It's a good addendum. It kind of walks you through the process. You guys know the security deposit, the current owner is holding a security deposit. If the new owner is going to keep the tenants in there, the security deposit is going to be transferred to the new owner. The rent's going to be prorated for that month, depending on when the settlement date is. Obviously it's a very helpful document. It'll kind of walk you through the process, but the main thing is don't forget it, and don't think that any lease will terminate automatically. Don't think that if the property is tenant occupied that magically they're going to move out on the settlement date and your buyers will be able to move in with no problem. That's a discussion you and the buyer's agent, the listing agent would have to make sure that there's a clear understanding on that. But anyway, for our purposes today, that's the new sentence. That was a little extra editorializing for you guys. Let's keep moving down here. This is the section 2, payment of the purchase price. And again, nothing is highlighted because it's the same terminology, the same verbiage, just different paragraph numbers. And we didn't bother to highlight that. Section 3, property condition and inspections. This is probably the biggest change to the contract and the most substantive change to the contract. The concept that the task force was really working on and pushing to get was really to have our contract be a true as-is contract. So all of this section here, property condition and inspections, that's sort of consistent with that intent that this is really going to be a true as-is contract. I don't know if anybody noticed, but the termite paragraph is not included in the body of the contract anymore. That's going to be in the property inspection addendum. So that's a significant change. All right, so here we've got inclusions, exclusions is the first paragraph here. Included all permanently attached fixtures, certain other now existing items which may be considered personal property are included if identified on a disclosure of inclusions, exclusions, leased items, and utilities addendum attached here too. So again, I would assume the seller is going to complete that form. I would assume the listing agent would upload it onto Bright MLS, right? You'll see what's included, what's excluded. The buyer's agent could include that as part of your offer. The buyer will sign it, the seller will sign it. There's an agreement as to what's excluded. Well, I guess you could negotiate theoretically, but let's assume there's no negotiation. There will be agreement about what's included, what's excluded. The listing agent isn't going to have to copy anything over. The buyer's agent is not going to have to copy anything over. That's going to be the addendum to the contract. So the inclusions, exclusions part of the contract, all those little boxes, that's gone now as well. And the addendum to the listing agreement is going to be utilized for that purpose, included as an addendum to the contract. Again, this is the same condition of property and possession. This is the same thing. It's just highlighted because it moved really. Seller's going to deliver possession of the property vacant, clear of trash and debris, broom clean, in substantially the same condition as existed on the date of contract acceptance. So that's basically the same as it was before as well. Inspection contingency, some of you may have called the legal hotline a time or two. There was some confusion, especially over the past year, where there were a lot more as-is transactions, and sometimes an as-is purchaser wanted to have the right to do inspections. And the way it was worded previously, sometimes there was some confusion. If they're just doing an inspection for informational purposes only, does that count as an exception, as an inspection, excuse me, or should that be deleted? What was that? So this hopefully is a little bit more clear. Basically, we're going to do an inspection. We're going to do inspections, and the inspection addenda is attached, or the buyer's declining inspections. So I think that's a little more clear as well. If the buyer wants to do inspections, you have to use the inspection addendum, period. Okay, so that's pretty straightforward, I think. And again, that's the verbiage was essentially the same. This sentence is added. Any buyer inspection contingency must be established through addenda to this contract. So again, that's consistent with a true as-is contract. No addenda, no inspections. You're taking it as is. Okay.
Kathleen.
Yes.
Sorry, do you want to pause periodically for questions or wait till the end of your presentation?
I can pause here. This is a pretty good place to take a pause.
Okay,
Any questions?
I figured. Yes, there are some. So there's one asking, will this apply to vacation rentals?
Will this apply to vacation rentals? This is the residential contract of sale. I'm not sure I understand the question. You're not using this contract unless, is it the sale of a vacation rental? Is that what they're talking about? Leases?
Hey, Walt, can you put in the chat or Q&A? What he said, when there was a lease disclosure.
Well, I guess the addendum I referenced, for the tenant occupied addendum, that really is more referring to a longer term tenancy, not a vacation rental where you have somebody for a week, somebody else for another week. So I mean, we could talk offline if you wanted to, but I would assume that addendum would not typically be used in a week to week a vacation rental situation. That'd be more for a long term tenant.
Okay, somebody else said, so there is no longer an as is addendum?
There is no longer an as is addendum. That is correct.
Okay.
Is everyone doing cartwheels and singing hallelujah? I know over the past 12 months, 18 months, we had a lot of questions about that as is addenda and the way it was not being utilized as intended. So basically the way the contract is structured now, if it's going to be a true as is transaction, if the seller is not going to make any repairs or not willing to do anything, if the buyer is willing to accept that and is okay with that, then they just have to sign the contract. They don't need any addenda. There are some other, there's a few, we call them additional as is provisions. We'll talk about that in a minute, but essentially the contract as written is an as is contract. If the parties truly want it as is, they don't need any addenda.
Okay, will Anne Arundel County's residential property information addendum no longer have the inclusions/exclusions since it is now part of the contract?
That's a question. I don't know that, honestly. Anne Arundel County, their forms committee handles that separately. I would, that would be something that the Anne Arundel County Forms Committee should look at. I would imagine they would remove it because it would be redundant, and just, that's a possibility that someone might make a mistake and the two might not be consistent. So I would assume that they would make that change, but I can't speak for the Anne Arundel County Forms Committee.
Given recent high-profile incidents regarding termite infestations and damage, etc., what was the rationale for removing the termite paragraph?
The termite, the buyer can still have a termite inspection, of course, if they want. The only difference is that termite inspection was added to the property inspection addendum. So that was just, again, it was just to make the contract itself, to remove all of the property inspection paragraphs from the contract itself, and all of the property inspection paragraphs are now included in that addendum. The buyer can select which inspections they want to have performed. The buyer and seller both will initial and agree to it. But that was really just to be consistent with the as is concept for the contract as a whole. But that's important. That's an important question. If you have a buyer, especially a VA buyer, you want to make sure that if the buyer wants to negotiate repairs, you definitely want to make sure that you include that property inspection addendum and check on there that the buyer is going to do a wood destroying insect inspection, and that would give the buyer the right to ask the seller to make repairs, or or pay for something, or give a credit. So that's important to remember to use that. All right, let's do one more question, Sarah.
Okay. Let's see. There are questions asking that we hold off on questions until the end.
Okay, excellent. I will agree with that. Yes.
Yeah. Okay, let's do that.
Yeah, because we have a lot to get through. I wanted to take a couple, but we can't slow down too much.
Yeah, good call.
All right. So this one is relatively straightforward. That's what I'll do. I'll pause if there's something. We've received questions on some of these already, so I kind of know where most of the questions will come from. So we'll pause on those. Some of the other ones we'll just go through quickly and hopefully allow some additional time at the end to respond to those questions. All right, so here, this is, again, like I had said, property specific disclosures. There's just a new sentence in here, really. I guess it's a paragraph technically. The property is not part of a condo or an HOA, right? Unless acknowledged by an attached addendum. So again, if it's part of a condo or HOA, everybody knows those addenda didn't change, but you're going to use those addendum. Make sure they're included. If you don't include them, you're making a representation that the property, or the seller is making a representation, excuse me, that the property is not part of an HOA or part of a condo. So just pay attention to that, which hopefully you were previously. So again, these are just, property specific disclosures. Is it agriculturally assessed? Conservation easements? These are all the same. You can see it's not highlighted. The paragraphs were moved, but they were not changed substantively. All right, so again, general disclosures, like I had said, these are essentially the disclosures that are required by Maryland law. The disclosure disclaimer statement, is the property subject to a ground rent, lead-based paint? Again, if you see no highlighting, that means the paragraph did not change. This property inspection brochure, that paragraph did not change other than the link was wrong. I think the name of the document was wrong. It had been updated, so we just updated the title of the document and the link. There's no significant change there. Flood insurance, again, none of these paragraphs changed. There wasn't anything else really that changed until, let's go down here, transfer of title and closing, right? Section 6. Again, nothing changed these first couple paragraphs, but we're going to go to everyone's favorite paragraph from the old contract, recordation and transfer taxes, right? The first-time home buyer. Remember, I had said earlier, there's no more, the first-time home buyer addendum is gone. That was confusing to a lot of people. For the most part, you really haven't needed to use that for several years. If the agreement was that the parties were going to split recordation and transfer 50-50, you did not need to use that addendum. But I think everyone on this call knows that people were using it anyway and putting that everything was going to be split 50-50. So it was a little bit redundant. And I think the way this paragraph was worded previously was confusing to people. I won't even say I think, I know, because we did get a lot of calls and questions on the legal hotline. So we can just read through this quickly. But again, the basic concept here is that now the way this reads, the assumption is the default is that everything is going to be split 50-50. Right? If the buyer is not a first-time Maryland home buyer, payment of recordation and transfer taxes, recordation and local transfer is going to be divided equally between buyer and seller unless otherwise specified here. So if it's not going to be 50-50, you would put, seller 70, buyer 30, whatever you want to put in there. A couple people have asked, should we leave that blank? Should we put in NA? Should we draw a line through that space? I would say, honestly, talk to your team leader, your office manager, your broker about what their preference is. But I would say, don't leave it blank. Attorneys don't like blank lines. Someone might come back later and think that you just overlooked it or you forgot it. So I would say put something in there, put not applicable, or, strike through it, whatever, but NA or not applicable would be my recommendation. And again, if you put NA or not applicable, everything's going to be split 50-50. If it is something other than 50-50, then you would put those numbers in there. Again, being clear, don't just put 70-30 because what does that mean? Who's going to pay the 70? Who's going to pay the 30, right? So just be clear in whatever you put in there. Make sure you express what the parties have actually agreed to. The first-time home buyer, again, this is just stating existing law, hopefully in a more user-friendly way that makes it a little more clear. Maryland law provides that the amount of state transfer tax due on the sale of a property to a first-time Maryland homebuyer is reduced from 0.5% to 1/4%, right? Everybody knows that, and shall be paid entirely by the seller. That's underlined, that's Maryland law, that's non-negotiable, right? Payment of recordation taxes and local transfer taxes will be divided equally between buyer and seller unless otherwise stated here. So the same thing as above. The default is it's going to be 50-50. If it is going to be something other than that, you would fill that in there. And again, my recommendation would be to put NA or not applicable, something. I just wouldn't leave the line blank. I think that just leads to mischief. All right, so I think this is fine. Buyer should check the box on page 10 of the contract indicating that buyer is a first-time Maryland home buyer and complete the required affidavit at settlement indicating the buyer is a first-time Maryland home buyer. So that box on the last page, or page 10, is still there. And as a courtesy or convenience to the title company, you want to make sure that that box is checked, and the buyer should understand they're going to have to complete some forms at settlement to confirm that they are a first-time Maryland home buyer. Non-resident seller, this is really sort of helpful verbiage that was added. You guys know Tom Drexler, who chaired the task force. He was he's a title guy. So he has a lot of familiarity with this, and he wanted to add verbiage in there just to make sure that sellers understand if the sellers are not a Maryland resident, or if it's an entity that's not licensed to do business in Maryland, there is an additional withholding tax. And there just is an explanation in here. Seller may request the Maryland Comptroller to issue a certificate of full or partial exemption from the withholding requirements, provided that such request is filed not later than 21 days prior to the date of closing. And then there's a link there with additional information. I haven't done settlements directly in a while, but from when I did, I know that department the Comptroller's office was very good and generally did satisfy that 21-day timeframe without any issues. So that's just a little bit of additional language there to help your seller, let them know that they should request that. And again, listing agent, make sure that they are aware of that and make sure that that's requested at least 21 days prior to settlement. I don't think anybody should have questions on that. It's pretty much the way things are done now. Title insurance, this is again a little bit of just helpful language in here. Buyers encouraged to purchase owner's title insurance. The main thing here, buyer understands a policy issued to the lender will not protect buyer from losses caused by title defect. I know that all of you guys are aware that there's 2 title policies issued generally. There's going to be an owner's title insurance policy and lender's title insurance policy. And again, I think coming from the title company's perspective and sitting at the table perspective, I think sometimes sellers don't understand, if the lender paid for a title insurance policy, I guess that means I don't have to. And this just explains no. The lender's title insurance policy does not protect the owner, does not cover the owner. So if the owner wants title insurance protection, the owner would have to purchase an owner's title insurance policy. And then again, a little bit of CYA, I guess, for all of us. The buyer understands the broker does not warrant the condition of title. Buyer agrees to hold harmless the broker from any damages sustained by buyer that may result from a defect in title. We have real estate brokerage license. We provide real estate brokerage services. We are not doing title abstracts. You're not making any assurances or guarantees about title. So that's a helpful sentence in there as well for, some protection for us and also to provide clarity to the buyer as well. This again, just breach of contract and dispute resolution. There just was another clause, I guess, added in here, subject to the deposit paragraph of the contract. Again, that's basically the deposit paragraph is essentially just consistent with Maryland law, and it says the deposit can be released if both parties sign a mutual release of deposit, if the buyer and the seller both sign that. And then under the Brokers Act, there's a couple other things. We could do a interpleader or the 30-day letter. We're not going to talk about that, but basically just everything ties back to the deposit paragraph, and that really loops into the Brokers Act. All right, so that is pretty straightforward, I think. Let me think. The next change is, again, hopefully you guys will like this. Most of our timeframes flow from the date of contract acceptance, within X number of days of the date of contract acceptance, correct? Well, what the heck is the date of contract acceptance? Well, even if it's your first transaction, you will now be able to answer that because the definition is right here. Insert the date on which all final initials and signatures of all parties have been affixed to this contract. So that's what the date of contract acceptance is. If your client asks, that's kind of weird. What date does that mean? Is that today's date? It's the date on which all final initials and signatures of all parties have been, affixed to the contract or made on the contract. So that is pretty straightforward. Let me go through. I'll keep going. This is probably this is worth talking about, and then maybe we'll take another little pause for a couple questions. Additional as-is provisions. Like I said, with removing the termite paragraph, the intent really was to have the contract itself be a true as-is contract. This is something to think about, I guess, especially if you're representing a buyer. The way the property condition paragraph is written, it does say that the seller is going to convey the property, free and clear of trash and debris, broom clean. You guys know in some transactions, the seller is not willing to do that, not able to do it for a variety of reasons. It could be an estate sale. It could be maybe a short sale where the seller doesn't have a lot of financial wherewithal to be doing a lot of things. So if that is the case, if the seller is not going to convey the property, broom clean, free of trash and debris, the parties can agree to that. The buyer can say, oh, I'm okay with that, seller. You don't have to clean the property. I've got, my brother's a contractor. He's going to clean the property. I'm okay with that. So the buyer and the seller would both have to initial this. If the buyer and seller both initial this, then the seller would not be conveying the property free and clear of trash and debris and broom clean, okay? So that's paragraph A here. Paragraph B involves HOA and condo associations. If there's a notice of violation that has been issued with respect to the physical condition of the property. You guys, this is not talking about past due assessments or anything, right? That's separate. This is the physical condition of the property. The HOA association has issued a notice that the grass needs to be cut. You need more mulch around that tree, whatever it might be. If the parties both initial this, the buyer would be saying, hey, seller, I'm aware of those notices of violation. You don't have to take care of them. I don't want you to paint the deck the proper color because I know you're going to use some cheap paint and do a lousy job, I, as the buyer, am willing to accept that risk. I'll take care of that property condition issue, that violation when I move in. I'll paint it the color I want, if the, consistent with the HOA. Seller, you don't have to take care of that, right? So the first one, this one, excuse me, is condo or HOA requirements. Notices of violation, where the buyer says, seller, you don't have to fix those. I will take care of those. And paragraph C, the same type of thing, but that's going to be from a city or county. Any requirements for the seller to comply with violation notices or requirements noted or issued by governmental authorities. So, I don't know, clean it or lean it thing, Baltimore City, some of the jurisdictions will do that. Again, if you don't cut the grass, Baltimore County will issue a violation. The same thing if the sellers, it's an estate, maybe the sellers are not going to take care of that. The buyers can say, that's okay, I can take care of that after I move in. Buyer and seller would both initial this, and then the seller would not have to take care of those things. If you're representing a buyer and the buyer is not cool with that, if the buyer says, hey, why should I take care of those violation notices? I want the seller to take care of those. Then your buyer would not sign these, would not agree to this, and the seller would be obligated to convey the property free and clear of trash and debris. The seller would be obligated to take care of any notices of violation, cut the grass, paint the deck, whatever it is, or take care of any, any violation notices issued by the city or county where the property is located. All right, do we have any questions? Should I pause now?
If you want to, are you able to look through the Q&A? There are definitely questions.
All right, let me see what we've got here. For informational purposes. If you want to do as is for informational purposes only, can buyers still do that and walk away? Yes, we're going to talk. That's the next addendum. We'll talk about the property inspection addendum. We'll talk about that. Every listing sold as is. Sellers, buyers, sellers, the bottom of each page. No, the seller and buyer do not initial the bottom of each page in this new contract. That was a decision. It wasn't essential that they initial every page. Legally, it's not, it doesn't make it invalid if somebody missed an initial on one page. So that was changed. This might be a good time to throw out any of the changes that were made. If you guys are unhappy with them, or if you see, as time goes on, if you see that it's causing a problem in transactions, we do have a statewide forms committee. They meet regularly throughout the year. Several of you on this call are members of that. I would suggest you could bring your questions or issues to the attention of somebody who's on the statewide forms committee if you want. You could address questions to me, Kathleen Dartez at mdrealtor.org, or James Beslity. It's James, James .Beslity, B as in boy, E, S as in Sam, L-I-T-Y, at mdrealtor.org. And if you have questions or suggestions, what happens, we would put those on the agenda for the statewide forms committee, and the committee could talk about it. If it's something that's occurring with some frequency, or some mistake or some recommendation that makes a lot of sense, the committee can take a look at that, and if they approve it, then it goes up the chain, and hopefully that will be put into place. As is with right to terminate. We'll talk about the property inspection. The right to terminate, I think, gives a lot of information on that. A lot of these deal with inspections. Inspections not asking for repairs. Yeah, we'll talk about I think I'm going to stop.
So,
buyer state transfer taxes waived, not first-time home buyer. First-time home buyer is true. All right, so I think I'm going to stop here. A lot of these questions will be answered probably by the next addendum that we can look at, right?
Kathleen, I'll also make sure I put your email address and James's email address in the chat. So if your questions don't get answered live by Kathleen, because we do have a lot of questions coming in the chat and the Q&A, if they aren't answered live today, you'll have her email address to email her the change or the questions.
Yes.
Thank you.
Thank you, Sarah. Yeah, we're happy to do that. All right, so this is the property inspection addendum, right? And this is, well, let's look at the first page here. It looks a lot cleaner and more streamlined than the existing document, right? Which hopefully is a good thing. So basically, this is the buyer and seller are going to agree that the buyer has the right to do these certain inspections. The initials, the buyer has to initial and the seller has to initial to reach an agreement. If the seller doesn't initial, then they're not consenting to allow the buyer to do that. There was some discussion about that. I think in general, obviously it's helpful to have it that the seller has agreed. Sometimes for whatever reason, sellers change their mind midstream or something, and we've had a couple questions where the seller maybe wants to deny access, they won't let the radon inspector in, or they won't let whatever inspector in. I think, you know, hopefully that won't happen, but if that does happen, I think if you have the seller's initials here saying, hey, you agreed to allow the buyer to do a radon inspection, that might help a little bit. Let's hope. But anyway, the bottom line is the buyer and seller both would initial for whatever inspections are agreed to. You'll notice previously there was a little bit of an explanation about each inspection and what it meant. And the discussion was, and the decision was, the way it was worded previously, it wasn't actually a definition of the inspection. I think most of them said, the inspection, the inspector would take a look at, things including but not limited to. So it really wasn't a definition. So that's why the decision was made to just streamline it and just list the name of the inspection. Again, if this causes problems or is challenging for people, please let us know. The committee could certainly revisit that. But as of today, that's the decision that was made by several groups, and fingers crossed, let's hope it works. You'll see on here, wood destroying insect, that's on here now. That's that was the paragraph that was removed from the body of the contract. If a buyer wants to do a termite inspection, well, we're being a little more inclusive now. We're not just saying termites, we're saying wood destroying insect. But if the buyer wants to do that, the buyer would initial here, the seller would initial here, and then the buyer would have the right to do a wood destroying insect inspection as well. Down here, important to note, right? Buyer's right to inspect and or test well and or septic systems, water quality, water yield shall be reserved through separate addenda. Right? So that's going to be separate addenda. That's not part of this. If there's a septic that you want or water quality, you're going to use those separate addenda, the same addenda that we have today, right? This is the additional language down here about VA. If buyer intends to obtain financing through the VA, buyer retains the right to conduct an inspection for wood destroying insects at their expense pursuant to VA regulations, notwithstanding the agreement of the parties stated herein. So a buyer who's going to utilize VA financing does have the right to have a wood destroying insect inspection performed. The thing that I would point out, though, if the buyer wants to negotiate with the seller, have the ability to negotiate to, if there's damage detected and the buyer wants the seller to pay for it, or if the buyer wants to, allocate the costs in some proportion or negotiate in any way, they do have to utilize this form, this property inspection addendum. The VA financing addendum by itself, it authorizes the buyer to, to do the inspection, but it doesn't authorize any kind of negotiations or back and forth with the party. So just keep that in mind, especially if your buyer is going to be using VA financing. If they want to have the ability to negotiate any damages or repairs or costs with respect to wood destroying insects, they do need to use the property inspection addendum. So keep that in mind. All right, so the first paragraph, nice and clean. I think everybody probably likes that. I will read this paragraph out loud. This was one of the questions that had been asked in the chat. Right to terminate. This one, pay attention, everybody. If you have zoned out or not paying attention, listen up. If the results of an inspection are unsatisfactory to the buyer, right? Buyer has done one of the inspections listed above. They're unhappy with the results. Buyer may terminate the contract of sale by delivering a unilateral notice of termination under contract of sale to seller by the deadline. And whatever the deadline was, 5 days, 10 days, whatever deadline was selected up above, that's the deadline for all of these inspections, right? So the buyer has the absolute right to terminate by that deadline using a unilateral notice of termination. Buyer is not required to specify the basis of buyer's dissatisfaction. Buyer's right to terminate this contract of sale, as stated in this subsection, expires at the deadline. So buyer has the right to unilaterally terminate the contract if they're unhappy with the inspections. They do not have to provide a copy of the inspections to the seller. All right, so I know might be some questions popping up in the chat on this. This is something some people have strong feelings in support of this. Some people have strong feelings in opposition to this. This is a terrible idea. If the buyers have the unilateral right to terminate, sellers aren't going to want to accept those offers. I will just remind everybody of when with the as-is addendum, where buyers were supposed to be doing the inspections for informational purposes only with the right to terminate. quite a few buyers and buyers agents sent over a copy of the inspection report, asked for repairs, and essentially used that report as leverage. Like, hey, now you listing agent, now you seller, now you know about these things. You seller, you know about these latent defects. Listing agent, you know about these material facts. Now you have to disclose that stuff. So with this paragraph, again, hoping it's used as intended, none of that would happen. The buyer is going to do their inspection. They decide they don't want to move forward. They just terminate the contract. They do not send a copy of the report to the seller. And again, we've had a couple questions about this already. I'll just go ahead and ask it, just mention it in case anyone's thinking this. Well, my seller's not going to like that. I didn't like that. And the old addendum, that little box, we never used that box because the seller didn't want the buyer to have the automatic right to terminate. Some people had asked, well, what can we do if the seller doesn't like that? You could strike through this paragraph. I would say, again, talk to your broker, your office manager before doing that. You know, if the seller instructs you, you would do that. Again, speak to your broker or office manager first. I would caution you, however, this paragraph means the buyer can terminate and not give you a copy of that home inspection report. If you strike through this paragraph, if the buyer wants to terminate, they're going to give you a copy of the home inspection report. They're going to try to negotiate pretty much back to the old addendum with the process there. So if this paragraph is removed, it's more likely, just to be blunt, it's more likely that the listing agent and seller will receive a copy of the home inspection report and may be legally obligated to disclose things. So just keep that in mind. We all know how people can be. If you're talking to a seller today, they might think this is, oh, strike through that. I don't want that on there. 3 weeks from now, they get a copy of a home inspection report showing that there's $25,000 worth of damage, and now they have to disclose that if this first buyer, if the buyer walks. They might not be so happy about striking that provision. So just be careful with that. Just be careful. Like I said, talk to your broker, your office manager before you agree to strike that, and maybe just think about how to explain that to your seller. I think some sellers will be fine with it. Some buyers will be fine with it, but that is a change. That is a change, and the buyer does have the right to terminate automatically and would just deliver a unilateral notice of termination, would not have to provide a copy of the home inspection report. So again, if you have thoughts on that, feel free to share them with me, with James, or with anyone you know in the statewide forms committee. That might come up again. There's some hot feelings, strong feelings on that one. All right, so again, the way this goes, instead of terminating the contract of sale, if the buyer doesn't want to terminate, the buyer can make a request for repairs and or seller credit, consistent with the same thing. The buyer is unhappy with the inspection, but still wants to go forward. The buyer is going to ask, hey, seller, will you fix A, B, C, or D, and maybe give me a small credit, right? So that's going to be done the same way. The property inspection notice is going to be utilized for that. That right, again, is going to expire by the deadline. So again, you, especially as the buyer's agent, keep track of the deadline, make sure you are responding appropriately within that time frame, right? In this case, if the buyer is going to negotiate, they are going to give the seller a copy of the home inspector's report, same as before. And then the seller is going to respond within 5 days after buyer delivers that notice, the request. Hey, seller, I want you to fix A, B, C, and D. And seller is going to respond the same thing again. Basically, I'm going to do some of those. I'm going to do all of those. I'm going to do none of those, right? So the seller is going to respond, or if the seller doesn't respond, then the ball's back in the buyer's court. Buyer, by written notice to seller given within 2 days of receipt of the notice or the date that they should have received the notice, the buyer can either terminate the contract or waive the requested repairs, in which cases the contract can remain in full force and effect, right? So seller doesn't respond, or seller says, I'm not going to do anything. The buyer can then terminate or move forward anyway, right? So that's again, the same as it is now. If buyer fails to timely notify seller, then the contract's going to remain in full force and effect. So if buyer drops the ball, then the contract's going to stay in full force and effect, and seller's only going to fix whatever it was that they agreed to, right? So I think that, again, is pretty straightforward and consistent with the way that it has been. The buyer has to check with the lender to make sure that, the credit can be fully utilized. I think that's, again, consistent with how things are done now. This is kind of the new part. And again, I know a lot of you guys in Howard County, you're close enough to Montgomery County. A lot of you have seen the HCAR forms or used the HCAR forms. HCAR's had this policy or this process in place for a while, where there's an additional negotiation period after that. And again, this was discussed by the statewide forums committee, and there is now a process where negotiations could continue and essentially additional negotiations. Within 2 days after delivery of a counteroffer regarding the requested repairs and or seller credit, the receiving party, right? So the seller's buyer asks for $5,000 credit. The seller responds and says, I'm not going to give you $5,000, I'm going to give you $3,000. Previously, the buyer had basically take it or leave it, take it or terminate. Now the buyer can respond, well, okay, I don't want $3,000, but how about $4,000? Right? So the buyer has 2 days to respond again with a counteroffer saying, I would like a credit of $4,000 instead of the $3,000, right? That counteroffer has to be made within 2 days, and the receiving party has to respond. And again, they can accept it, continue negotiations by making a further counteroffer, or deliver notice terminating the contract of sale. So that's basically where it goes, a little bit more back and forth. Yes, I'll do this. I won't, or I'll terminate the contract, right? And this last part down here, failure of the receiving party to timely respond to any counteroffer shall constitute their automatic acceptance of the counteroffer, with all other terms of the contract of sale remaining in full force and effect. So again, buyer's agents suspect, well, both agents in this case, when you're doing counteroffers, pay attention to those timeframes. If you don't respond within 2 days, you're going to be deemed to have accepted it. And the terms of the contract of sale are going to stay in full force and effect. And again, the thought process is we want the default to be that the contract continues, right? The contract exists as a valid contract. So if your client is unhappy with it, absolutely, positively, do not miss that 2-day time frame. You're going to respond saying you're terminating your client's terminating the contract. So just be, again, extra cautious. You have to be mindful of days anyway, but in this process, you do have the benefit of additional time. That also means the burden of additional time frames and deadlines that you have to be careful to comply with. Okay. And again, if the party terminates the contract, the EMD, the deposit is going to be handled consistent with the deposit paragraph in the contract, just as it is now. All right, so I think this is, again, this is fine. The seller has to make the property accessible. This is the same. I don't believe anything changed in these paragraphs. All right, so that is a little bit of a change. Let me go to the next one. This is the property inspections notice. I think the cool kids call it the PIN, right? The PIN. And again, this is your buyer wanted to do some inspections. They checked the box, the buyer initialed, seller initialed. They've done their inspections. They're going to request some repairs. There's some things in the report they're not entirely happy with. They're not so unhappy they're going to terminate. They're going to try to negotiate a little bit, right? So this is sort of a typical transaction, typical process, right? Again, here, the same verbiage, I believe. The inspections provided herein are not for the purpose of making items of a routine maintenance or cosmetic nature the subject of further negotiations. That's consistent with the previous version. And then here's the notice. It's going to help buyers and sellers, negotiate. Notice pertains to the following inspections. So the buyer should check whichever inspections they were dissatisfied with, what they're requesting the seller to take action, radon, whatever it might be. They should make sure they check the right box. And then again, the notice is going to be given. There's nothing unsatisfactory. The buyer's not requesting anything, not requesting the seller to do anything. Great. I don't think we've ever had a call on the legal hotline where that happened. You may have never had a transaction where that happened, but anyway, that is there. It's possible. Theoretically, the buyer could not ask for anything, or the buyer wants something to be done, right? So they're going to include a copy of the home inspection report and ask the seller to do certain things, take certain corrective action, and or offer a credit, right? So the seller is going to respond. The seller is going to fix everything, right? Again, buyer should be happy, no response is needed, or the seller's not going to do anything, or the seller's going to do some, but not all. And then again, the same thing, the seller has the option to offer a credit to the buyer. Now, this again is where I'm going to add a little bit more down here. The buyer again has received seller's response. The buyer has to, respond to the seller. The buyer either says, okay, that's fine. It's okay that you're only going to do A, B, and C. I'm ready to move forward anyway. Or there could be a credit. The buyer will be okay to take the credit instead of that. Or the buyer can terminate, right? Or this is the new part, buyer can propose a counteroffer, right? Like I said, let's assume the seller came back and said, I'm not going to do all those things you asked for. I'm going to give you a credit of $2,000. The buyer can say, I'd like a credit of, maybe $4,000 and we could maybe, have something, maybe be able to work something out. So the buyer in here could request a credit of $4,000 rather than the amount that the seller had offered. And then again, there's an ongoing process anticipated here. Again, the seller can say, okay, I can live with that. I'll give you the $4,000 credit, or the seller can terminate. No, I'm not going to do that for you. I'm not going to do anything. I want to terminate the contract. Or the seller can say, oh, I'm not going to give you $4,000. I'll give you $3,250.42. The seller could respond by that with a counteroffer. And again, the same time frame, the buyer would then have 2 days to, I'm sorry, the last one. This is the final version. The buyer basically says, yes, I'll take that, whatever number I just made up. I forgot it that quickly. Yes, I'll accept the credit in that amount. I'll accept that. Let's move forward with the contract, or the buyer can terminate the contract. So that's a little bit different process than we've had. Again, like I said, for a lot of you, I don't think it's going to be that much of a significant change. I know HCAR's had that back and forth process for a while. Coastal folks, that might be different for you. I don't think that you got, I don't know about Delaware, but possibly you've seen that as well. But anyway, that is a different process. And I think, again, the thought was that in reality, a lot of times the buyer and seller go back and forth anyway. And if you just make the buyer make a decision right up front, like I'm going to either accept something I'm not happy with, or I'm going to walk. In the real world, I think oftentimes they really want a little bit more back and forth and more of an opportunity to negotiate. So this revised form basically anticipates that, and hopefully is more consistent with what happens in your actual day-to-day practice. Let me take a couple seconds here and look for the questions here. Is there any? Data contract acceptance, we're going back in here. If contract is as is, to sell a broom clean. Yes, broom clean, that's a kind of an easy one. Yeah, the broom clean, unless they're using that additional as is, then the seller does have to convey broom clean. Yes, that was a good question. If they're not going to, if it's not going to be conveyed broom clean, you have to use the additional as is addendum, okay? Let me see, withholding tax, even if non-resident is on second home or investment property, or only on primary. I believe it's on, you better double check on that with the comptroller's office. I believe it would be on both, but I'm not positive. Okay, all inspections under the same time deadline. I've used different deadlines for different inspections. The way it's written, it is anticipated that there will be one deadline for all of those inspections. So again, that's a change as well. And be mindful of that when you're figuring out what that deadline is going to be, what that date is. The thought is that the buyer would request all of their repairs or corrective action all at once. The seller would respond all at once. So that's the way that's written. Again, if that turns out to be problematic or not feasible, feel free to contact us, and we could have the statewide forms committee look at that. But that your understanding is correct. It would be one time deadline, one time frame.
Hey, Kathleen, I think a lot of the questions are in the Q&A rather than the chat. Are you looking at? Yeah,
I was looking at the
Q&A.
The Q&A is better. Okay, let me go through the Q&A. Oh, no longer the 2% limit on termite. Yes, that is true. That has been removed. We'll see that the termite language is on, there's additional termite language on the VA addendum, VA financing addendum, but that 2% limit has been removed. That's a good point, a good observation. I should have mentioned that. That was another one. We had questions on the legal hotline periodically. I think a lot of people were not aware that the seller had agreed to that 2% number. But anyway, that's gone now. So that would be fully negotiable. If the buyer does a wood destroying insect inspection and it turns out there's damage, they would negotiate with the seller and ask the seller to, make repairs or provide a credit. The seller could agree or disagree. The 2% is not automatic anymore. So that's a good point. And thank you for asking. All right. Does anything happen to the agent for sending the report? Do I have to open the report? This is another question we were asked a lot over the past year or so, and the answer is yes. I mean, I know no agents like this, but if someone sends you by email, using Dotloop or using one of the apps or platforms that you have, if they send you a copy of the home inspector report, remember under the code of ethics, you're obligated to disclose material facts meaning things that you knew or should have known. if someone sends you an email with a copy of a home inspection report, you can't just, delete. You would have to be, you would have to open that and read that. So again, I know some people might not be happy with the buyer having an automatic right to terminate, but it does, I don't know if that's a protection or not, but at least it does hopefully alleviate that situation, and you shouldn't be receiving copies of the home inspection report. And wouldn't have to go through that with your seller. Is this a latent defect? Is it a material fact? You're going to have to disclose this. So hopefully giving the buyer the automatic right to terminate would hopefully minimize those situations where you would receive a report that you did not want to receive. That was the thought process anyway. I'm going to keep moving forward again, just in the interest of time. And, again, happy to go back to questions at the end or even afterwards, if that's easier. Let me see, conventional financing addendum is the next one that we had. This is not a huge, big change. There was one sentence added. This is if there's an issue with the appraisal. The appraisal is going to come in high or low or whatever, low. The buyer is going to want to reduce the purchase price. There was, someone had observed that there was no language dealing with a situation where the buyer didn't respond. Right? The buyer didn't tell the seller what they were going to do. So a sentence was added in here. If the buyer fails to provide written notice to the seller of their election within the agreed upon time frame, it's automatically constitute the buyer's agreement to purchase the property at the purchase price. Right? So that's again what was up here. So that was not included in the previous version. Someone had made an observation about that. So again, buyer's agents especially keep track of your time frames. If the buyer doesn't respond, the default is going to be that the contract continues as a valid contract and the buyer is going to agree to move forward. All right, let me go to the next one, the VA financing addendum. That is, let's see, the VA financing addendum, the one thing that changed, this is a process, the VA servicing manual, I believe it was, they updated their guidance. Previously, the buyer, the veteran, the VA purchaser, was not allowed to pay for the termite or any repairs. And that changed, that was a new change just June of this year. The VA servicing guide was updated, and a buyer who's using VA financing is now allowed to pay, yay, buyer paying more. But the buyer can now pay for the inspection and any repairs as well. So that was added in here just to be consistent with the updated guidelines. There's a link in there for the if you wanted to read the guidelines. But basically the key point here again, remember the buyer will have the right to do the inspection, the wood destroying inspection. If the buyer wants to negotiate and wants the right to negotiate, you'll see this document itself doesn't do that. They have to use the property inspection addendum to give the buyer the right to negotiate with the seller. Hey, there's damage. It's going to cost $5,000. I'd like you to cover that. And again, the seller can say, nope, we're not going to give you $5,000. We'll give you $3,000, and the same back and forth process we just talked about. But and again, the title of this paragraph was changed. Before it said termite. Now we're using wood destroying insect consistently throughout. So that's, like I said, that's the only new language in there. FHA financing addendum, just the only change was just same thing, just verbiage. Rather than saying termite, we're using wood destroying insect consistently throughout. So that's the FHA. Let me see, FHA, VA, let me find the other one up there. And USDA as well. Just the same language, same language was added. Where is it? Wood destroying insect. In all transactions involving USDA financing, all fences and outbuildings should be included in the inspection certification. That's just so the phrasing is consistent throughout all of the addendum. All right. And this one I don't think hopefully won't be too challenging. I guess we will see. This is the BAT system, on-site sewage disposal. If the owner has a septic, there's some requirements that a failing system in the critical areas has to be replaced with the BAT system. I think what's the aerobic treatment unit is another phrase for that, or best available technology system. And this is just a disclosure where the seller is letting the buyer know that the septic system is the BAT system or the ATU system. And it's just giving, this is basically just from Maryland law. There has to be maintenance performed. It just tells buyer what the BAT system is. And the key for us, I think, is down here, this last paragraph, right? Within X number of days of the date of contract acceptance, the seller has to deliver all the BAT system documents, installation, inspection, any maintenance records, permits, whatever, all that documentation that the seller has. The seller is going to provide copies of all of that to the buyer, right? They're going to let the buyer know who the certified service provider is for the system, that's the provider who most recently serviced it, and they're going to let the provider know that there's going to be a sale and this is the name of the new buyer. So pay attention to that. Within X number of days, I don't know if you guys want to have that conversation in the chat or the Q&A. I will tell you honestly, I don't know what's the reasonable time frame there. I would suggest, again, if you're the listing agent, this would be a conversation you'd have with the seller up front. Some people are very good with their paperwork, others not so much. It would be good to mention this to the seller during the listing appointment so they could start to gather all their documents together and have that ready to go, ready to give that to the buyer, shortly after, whatever, within X number of days from the date of contract acceptance. So that is on there as well. And I think, let me see, that was really it for the addendum. Exclusive right to sell brokerage agreement. The only change in here, I don't even know that anything changed in here. The main thing that changed in here, where is it now? Am I going on to the wrong? There it is. Disclosure of inclusions, exclusions, leased items, and utilities. That's going to be, remember we referenced that already. That document is going to have multi-purposes now. It's going to be an addendum to the listing agreement, right? The seller is going to say this is included, that is excluded, and that same form completed by the seller is going to be then utilized as an addendum to the contract. The buyer and seller are both going to sign it, indicating their agreement that yes, this is going to convey, this is not going to convey, these are the leased items, et cetera, et cetera. So that's the only change there. And then this is the document itself. The disclosure of inclusions, exclusions, leased items, and utilities. Again, upon execution by buyer and seller, it's going to be an addendum to the contract. The seller is going to complete this part up here at the listing presentation, at the listing appointment, what's going to be included. And then it's going to be used, signed by the buyer, signed by the seller. It's going to become an addendum to the contract. Again, so far, I think we've received positive feedback on that. The paragraph in the contract with all of the inclusions and exclusions, that's all been omitted. So this is going to be the addendum to the contract instead. I guess my only caution is don't forget it. If you're the buyer's agent, especially if you want to make sure the seller does convey whatever it was they agreed to, make sure you include this as an addendum. Maybe in some ways it might have been easier before if it was in the body of the contract, but there was a possibility of error and mistakes if it wasn't consistent. So it should be easier now. Just remember to include it. Okay. That I think is it. Let me see, what else do we have? Change in terms addendum. This is a new form as well. You guys remember a couple of years ago, there was an addendum, change in terms addendum to the contract of sale. And what it was, it basically had a couple items in there that were sort of the most frequent changes that were needed. For the contract, it would be like a change in the settlement date, change in the price, right? So this is the corollary to that, the comparable document for a brokerage agreement, right? If you have a listing agreement, a buyer agency agreement, buyer-tenant relationship, or the unapproved land, any of the brokerage agreements, if you're going to modify it, you can use this addenda to modify the agreement. You would just check which agreement you're referring to, right? Your listing agreement, whatever it is. And then whatever the agreement is, again, these are the most common changes, or what we expect the most common changes would be. The term of the agreement, you're going to extend the agreement. It's supposed to terminate, the end of September. You're going to terminate it at the end of October instead. You would agree it's going to continue in existence, continue to be valid until midnight on 10/31/2022. Right? Listing price, again, you would change that there. The client would tell you they're going to list the property for whatever amount, or change the lease. They're going to offer it for rental at a certain price. They're going to modify that, change that. You want to get that in writing. Have your client sign it. The company name is going to be there, and presumably you're approved to sign for your broker. You could sign there. If you're not authorized to sign for your broker, you would have your broker sign there. But that was the thought, that might be a little bit more helpful than having you do an addendum and draft something. If these are kind of the most common things that would be changed, here's the form already ready for you, a template at least. You just have to pop the numbers in there or the dates in there. All right, and I think the only other thing I wanted to show you is a post-settlement occupancy agreement. Again, you guys who've been on the statewide forums committee know this has been talked about off and on for a while. It was never approved previously. I'll go on record saying I don't really like them, but that's neither here nor there. Who cares about my opinion? But again, because of the market, especially I think last year, the housing market is tight. Inventory is low, and a lot of times it was difficult for someone selling their property. Maybe the home they were moving into wasn't ready. Something had happened with that transaction. So anyway, just there were increasing numbers of sellers who needed to stay in the property after settlement. So this was brought before the statewide forums committee, and they did approve the post-settlement occupancy agreement. Again, some of your local boards have had one in place for a while, so this I don't think this is a new concept for anybody. But the practice guide that we had, the recommendation, basically your best practice is don't refer to your buyer, don't refer to the seller as a tenant, and you really don't want to refer to the money as rent, because you want us to be clear, this is not a landlord-tenant relationship. And there's a limitation on the days placed right up here. This agreement should not exceed 60 days. If it goes beyond 60 days, then it could be deemed to create a landlord-tenant relationship, and it's that much more difficult to, you have to go through certain notice periods, et cetera, et cetera. It could be that much more difficult to get the occupant out of the property if it's considered a true landlord-tenant relationship. So be mindful of that. But anyway, basically, here's the provision in here where the buyer and the seller can agree what the cost is going to be. The seller is going to remain in the property for X number of days, and here's what the seller is going to pay. Right, again, it's going to be done at settlement, going to be withheld from the seller's proceeds generally, or taken from the seller's proceeds. Nominal consideration, I don't know, $250, whatever nominal, 10,000, whatever nominal is to you and your client, you'd put that in there. Carrying cost of buyer, oftentimes that's going to be the PITI. The title company can calculate that if you're not able to, or your client isn't able to. It basically is going to be, you would figure out what their monthly mortgage payment is, divide that by the number of days. Get your daily rate, figure out how many days the person's going to stay. So it's just going to be, if it's X amount per day times 30 days times 45 days, and that's going to be your number there. Or again, they could just pick a flat daily rate. I don't know what a hotel in that neighborhood, whatever it might be, whatever amount they want to, or maybe they want to make that really high. They don't want the seller to stay too long. The seller is just not able to move out, today for settlement. They said they needed 4 extra days, 5 extra days. Maybe you give them a high daily rate to try and make sure they hold their feet to the fire, make sure they really do just stay there for the limited number of days. But that gives them some options there. A security deposit, you don't have to have a security deposit. Generally, I think most of these do have a security deposit. The title company or escrow agent is going to hold that security deposit, and then that's going to be utilized, I guess, when the seller moves out. Anything in excess of, here it is, right here's the language, in excess of ordinary wear and tear, then could be deducted from that security deposit, right? Seller, again, here is going to agree to deliver the property to buyer in the condition as required under the terms of the parties' contract of sale. So again, if the parties agreed the seller would not convey the property broom clean condition, this doesn't circumvent that or supersede that. If that's what was supposed to happen originally, that's what would happen here. If anything different is going to happen, then you should make sure to maybe have the title company assist in reducing that to writing. But basically, the default property condition is going to be whatever was agreed to under the contract. And then the seller is going to continue to keep utilities through the last day of the occupancy. There's going to be a final inspection, of course, see if there's any damages. That's would be taken from this security deposit. And I think that is pretty much it. Anything else you need to talk about? The disbursement of the security deposit. If the buyer doesn't make a timely claim against the security deposit, then the title company can release it. And that is basically it. Is there anything in here you guys want me to mention specifically? It says it's no landlord-tenant relationship. Let me mention the insurance paragraph. That's important because your clients will ask about that. Buyer shall maintain fire and extended coverage insurance on the property with an appropriate absentee owner's liability clause. Again, remember, settlement occurs today. The buyer owns the property. right? So the buyer needs to have insurance. God forbid lightning hits or something terrible happens, the buyer wants to be insured and have coverage in place, right? And the insurance company, if they think that it's going to be owner occupied and the buyer is not going to be in the property for 30 days or 45 days, make sure the insurance company is aware of that. You do not want to have them denying a claim because they were not made aware that the buyer wasn't going to be in the property. So just read that and make sure your clients understand this paragraph as well. They're going to ensure the seller would want to have coverage for loss of their personal property, right? Again, from the settlement date forward, the seller no longer owns the property. They're occupying the property. If there was a flood or something, if the seller's personal property was damaged, it would be best for seller to have coverage to protect their personal property so they could file a claim and recover any damages that way. So that's a good paragraph, and it may not be intuitive. The seller, they're moving, they're stressed, they're moving to their new house, they just need a couple days. They may not even be thinking about that, about insurance, and the buyer as well. If they're not actually taking occupancy and opening the front door and moving in, it may not occur to them that they need to have that insurance in place, but they definitely do, and they would need to make their insurance provider again as aware that they're not occupying the property, and they won't be occupying it for whatever time frame. All right, so that I think was it. We have a new commercial listing agreement and a commercial, an addendum to it, which includes, property condition items if things are included or excluded. I wasn't going to go through those because I didn't think we'd have as many questions about that or as much interest in that. Again, those forms are available on our website. If you want to talk about that, you can call me or reach out to me. I'll be happy to talk about those with you. But those are new forms as well for our commercial practitioners. All right, is there what should I do? Chat? Let me go through some questions.
There's some in Q&A.
All right. Excellent idea to include the insurance paragraph. Why, thank you, Lisa Soto. I have a lot of respect for Lisa Soto. I appreciate your opinion. That's thank you. All right, what should we do? Q&A, you think?
Yeah, look at Q&A. There are some questions in there.
Okay. I always did think 2 days needed to be extended. Contract calendar days, not business days. Yes, that's correct. Let me see, some of these we've gone through already. No longer initials and all. Yeah, we did those. Step down here. What's the date of contract when asked in an addendum? The date of contract for an addendum, I would use the date of contract acceptance. That should be consistent, right? What if the escrow agent does not want to be a part of this addendum? I would talk to the title company. I mean, I haven't worked at a title company in a while, but every title company I worked for, they did those pretty routinely. A post-settlement occupancy agreement, that's why I can calculate them pretty quickly. It's not that unusual. So the title company generally would take that. It would be shown on the settlement statement. I don't think that would be a problem. I would say talk to the title company. If there's a title company that doesn't want to do that or doesn't want to participate in that, maybe talk to your office manager or your colleagues in the office. Maybe there's another title company that is okay with it. But it's not that unusual, and I think even more so with the recent market with the shortage of inventory, it's not that unusual for a seller to want to remain in the property or have possession of the property at least for a couple more days or a couple weeks after settlement. When will we be required to use these forms if we have an old listing agreement form signed prior to that date, but the home is not under contract? Good question. These forms are effective October 1. All of the forms providers have them already. I guess they have got their IT guys or their IT folks working on it now, and everything should be available on all of the platforms, all of the vendors by October 1. I would say if you have a listing agreement right now that's not under contract, one thing that I would think about is the inclusions and exclusions, because going forward, that's going to be part of the contract. The new contract, remember, doesn't have inclusions and exclusions in it. So I would say think about that one, especially the inclusions and exclusions. You might want to, this is a suggestion actually I spoke with someone about yesterday, Barb Maloney. I don't know if you're on here, but it might not, again, talk to your broker or office manager. It might not be a bad idea to look at that exclusion addendum and maybe upload that to Bright MLS, because that, if the parties go under contract after October 1st, the new contract won't have those paragraph in it. That section won't be in there with the inclusions and exclusions. So that might be a good sort of preemptive move to make, to have that up and available, so your buyer could include that with the offer, and then it would be part of the contract. So that's something, I think that was a good question. If you take out the old termite 2% in the listing agreement too, I will double check that. I hope we did. We should have, if it's consistent. I'll double check that. Thank you. And again, feel free. Maybe I should be embarrassed, but I have no embarrassment about people asking questions. If you notice something 3 months from now that nobody else picked up, I'm not going to be mad at you. I will be grateful for your eagle eyes and for you catching something. Or even if things that we think are going to work, if you're out in the real world, your day to day, and you find something isn't working as anticipated or it's not happening, again, please give us that feedback. Let us know, and we can bring it to the statewide forms committee. And we want the forms to work, right, based on your business, based on reality. So yeah, please make us aware of those issues, any challenges, any suggestions that come up. Here's another one regarding termite damage. I don't believe a lender will give a mortgage commitment if there is damage, so the seller doesn't have to make those repairs now. I guess that would be negotiable, and the buyer and the seller would have to negotiate who's going to make the repairs, who's going to pay for it. Like the VA did change their guidance. Who was that? Shirley Matlock asked that one. Shirley, the VA changed their guidance, and the buyer can now pay. I guess it's in certain way, it's worse for the buyer now, because before the buyer couldn't, the seller had to pay. Now a VA buyer can pay. So it really is going to be something that would have to be negotiated between the buyer and the seller. All right. What about the code of ethics? I don't know what about the code of ethics. I'll skip that one. If somebody wants to respond to me directly or ask more about that, I'm not sure exactly what you're talking about, the code of ethics. Code of ethics, you should know what's in the contract. You should be able to explain it to your clients, so your clients know what's in the contract. They know what they're signing and what they've agreed to. Let me see. No longer initials in each page. I think we touched on these already. The PIN, the time frame, the 2 days, we went through that already. Who else? Does something happen to the agent for sending the report? Do I have to open the report? Yeah, we touched on that as well. Okay, let me see. I'll go in the chat instead. Okay. Oh, Barb Maloney, there she is. Okay. Kenny Smallwood, what is that? I don't know what that question is. Kenny Smallwood, what do you mean by no electronic signature in the listing agreement or buyer rep? I'll make a note of that. I'm not sure, Kenny, exactly what I'll have to look at them again to see, but I'll look at the brokerage agreements for electronic signature. I think that's been addressed, but thank you. I'll take a look at that and I'll let you know. Anybody else? Thank you. Thank you guys for all being here. Just as background information, just so you all know, Maryland Realtors, Chuck Caskey does a podcast. I'll stop that, share. You don't need to see that anymore. Chuck Caskey does a podcast, and a few weeks ago he did a podcast talking about the changes to the form. Tom Drexler, who led the task force, and James Bestlady, who's the primary staff person for our statewide forums committee, the two of them were on the podcast. So that's sort of an overview of the changes. We also have recorded a series of videos, short-ish videos. I don't think any of them are longer than 5 minutes. Some of them are 2 minutes. James recorded those. They are in post-production now, which you guys may have more understanding of what that means than I do, but basically they're recorded. I think the video company is copying and pasting some sections from the contract. When James references a particular paragraph number, they're going to zoom in on that particular paragraph. So if you look at the video, you'll see specifically which paragraph is being discussed. So those have all been completed. I think they're just doing final edits now. So hopefully, I would hope those would be available by the end of the week. I'm sure we'll send out some notice on those when they're available as well, but that's an additional training resources, training materials for you. Sarah had already indicated this session was recorded, and that recording is going to be available. So you can utilize that. One other thing I'll say, if anyone who's coming to the Maryland Realtors or coming to Ocean City next week for our conference, we're going to do another training session. Quite a few times at the conference, we've done a legal hotline live, a panel discussion about whatever the hot topic is that year. This year, I think we just discussed the hot topic. So our legal hotline live, it's going to be all of the attorneys from our legal department, and we are going to be discussing these changes to the contract. So if you want to look at the forums and mull it over and think through some things, talk with your team, talk with your office manager, you want to come to Ocean City next week with some more questions, feel free to do so, and we'll be happy to discuss those at the conference. And what else? Any other questions?
I think that's it. That's good. So there were definitely a lot of questions and we didn't get to them all. If your questions were not answered, please feel free to reach out to Kathleen directly. And yes, we will have this recording on our YouTube within the next day or so, and I will email it out to everybody who registered personally to make sure that you see it. So thank you so much, Kathleen. We really appreciate your time today.
Oh, thank you. Thank you for inviting me.
Yeah, absolutely. And thank you to everybody who logged on. We were so happy to host you today, and we hope that you enjoy the rest of your day. Thank you.
Yeah, thanks. Good seeing you guys. Well, seeing you in the chat. All right. Thanks, everybody.
Bye.